Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While you are waiting, we would like to share with you a short video of the firm. Please enjoy.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everyone. Thank you for joining us for today's online talk entitled Legal Agreements in Digital Technology. My name is Aaron Liu. I'm a pupil in Chambers with Mao Inquire & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mao Inquire & Associates is a mid-sized law firm that was founded in year 1985 by Datuk Mao Inquire. Our able team today comprises of 23 lawyers and a support team of 19 staff. Datuk Ma is today a consultant of the firm following his retirement from the Court of Appeal bench in year 2015. The firm continues its tradition today of working primarily with small medium enterprises, family businesses, and also individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration services, a dedicated employment and industrial relationship team, and a department that focuses on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are also supported by the talent from both our corporate and dispute resolution team. For today's talk, it is a part of our MWK online talk series. By way of background, we have been organizing monthly lunch talk at our office since year 2013, some of which were also broadcasted live. But with the current movement control order imposed due to the COVID-19 pandemic, we have moved the talks online in order to continue with our objective of sharing knowledge, raising awareness, and also encouraging networking for clients, potential clients, and in-house counsel. Please visit our website at mawinquire.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, for today's talk, we have two speakers for today. Ms. Cassandra will be speaking for the first part, while Mr. Tommy will be speaking for the second part. And we will then conclude with a Q&A session. Allow me to introduce you Ms. Cassandra, who is a partner leading our corporate department. She was called to the Bar of England and Wales in year 2011 and subsequently admitted to the Malaysian Bar in year 2012. She focuses in various commercial and corporate matters, including drafting project agreements and also M&A transactions. Our second speaker for today is Mr. Tommy Wong, who is an associate in our corporate department. He was called to the Bar of England and Wales in year 2017 and also admitted to the Malaysian Bar in year 2019. He also specializes in various commercial and corporate matters, including franchising and licensing agreements, regulatory compliances, and M&A transactions. Our speakers today will target to complete their presentation by 3:45 p.m. and will then take questions. If you have any questions throughout the talk, please don't forget to post it up on Slido or in the chat, and I will address them at the end of the talk. You can access the Slido page by scanning the QR code or going to the Slido website and key in the number #23481. For today's talk, there are 5 top points which will be covered by both our speakers. Ms. Cassandra will be leading the first 3 topics and Tommy will be covering the last 2. Without further ado, let us welcome Cassandra for giving her talk. Cassandra, over to you.
Thanks very much, Aaron. Just bear with me, everyone, while I share my screen. Right, there we go. Okay, thanks, Aaron, and a very good afternoon to everyone who has joined us today. Thanks for taking the time out and joining us. My name is Cassandra Tomasios. I'm the partner at the firm, and our talk currently today is on legal agreements in digital technologies. Now, as most of you know, due to the ongoing COVID-19 pandemic, digital technology has never been more important. There are several industries which have moved, if not all of them, most of them have moved their operations online. They have digitalized their systems and they're now turning to digital technology to advance their businesses. Now, with that being said, digital technology has obviously, as we all know, played a very pivotal role, especially in this day and age today, especially with the pandemic. So it is not only in Malaysia, but I think we see this around the world and across the globe as well. Businesses are striving to grow their companies, and they've now turned to digitalization to use technology in such a way where they can advance their business. So this may be in the form of data storage platforms. It could be online streaming services, online webinars like what we're doing now. So instead of the usual lunch talks that we give at the office, we are now doing it online. And with digital technology, this has allowed us to do this. Which has taken off exponentially because I think most of law firms that we know and companies as well now take a lot of their talks online and use online digital platforms to operate. Bear in mind though, throughout the course of this talk, we may interchangeably use certain words such as digital technology and information technology. But we will be using them interchangeably to be referred to almost at the same time and will commonly be used interchangeably as well so that you guys don't get confused. It would probably mean one and the same thing that we will be referring to. So with that being said, what you see on the screen now are the list of digital technologies that we currently have, especially in Malaysia, and things that are common here. Everyone goes on social media. Everyone knows that you do online banking through your bank systems and all technology ways that we have moved forward and progressed. But with that being said, I think it's important to know that there are certain concepts which need to be included or which needs to be drafted or put in place so that they operate according to what your needs and intentions are. Common agreements, I'll just take you through very briefly what common agreements probably entail, and this would probably include things like software development agreements. And what you see on the screen now is a list of common agreements which we will be touching on today. They're not comprehensive, and this is just a few. An example of this would be that, to name a few, software development agreements, support and maintenance contracts, end user license agreements, terms of use and privacy policies. And I think a lot of you would probably be familiar with end user license agreements, terms of use and privacy policies, because if you realize sometimes when you download app or before you download the app on your phone, you have to tick off a certain box at the bottom which says, please agree to the terms and conditions. And it's quite lengthy. You have to scroll all the way down. Those are usually referred to as terms of use and privacy policies, which most applications require you to consent to before you use the app. So I will be taking you through key areas on what you might need to know and what you might need to look out for. And those key areas that I will be touching on is software development agreements and support and maintenance contracts. Whilst I'll then hand over to my colleague Tommy later, who will do terms of use and privacy policies, which is the ones that I said you would probably most commonly see in applications when you download them. So without further ado, I'm just going to dive right in to software development agreements. So most of you will probably be wondering, what is a software development agreement? I have no idea what they are. What do we use them for? How do we use it? And where do we use it? So a software development agreement is sometimes also known as a master service agreement, and it falls under the umbrella of contract for services. So essentially, it is similar to contract for services, but is a particular umbrella of services where you're specifically developing software. And this could be in the form of a mobile application. It could be in the form of a website, or it could be in the form of any online platform that you are looking to create. And these agreements are usually entered into between a customer and a developer. So a customer would mean that you would probably be a client, a company, an individual, an organization that is then outsourcing the work to create, develop, and operate the application to a developer. So on the one hand, you have a customer, and on the other hand, you have a developer. And these agreements are used usually when you as a customer or as a client obtains their services from a developer to create, develop, or design a certain software application. Like I said earlier, it could be a website, it could be an application, or it could be any online platform. So examples that I'm going to give you for software development agreements, which are usually in these types of situations where they come in handy, would be when you are trying to set up an online website and you don't know how to do it, so you engage third party to do it for you. They will be known as the developers, and specifically to websites, they would be website developers. So then if you're creating a mobile application, which is a little bit more comprehensive, and companies usually outsource that to third parties, they would be the mobile application developers or creators. You could also perhaps engage software developers to digitalize certain aspects of your business. And an example of this is perhaps SSM. So for those of you who know the Companies Commission of Malaysia, otherwise known as SSM, they have, I think it was a couple of years ago, they digitalized submission and filing of all their annual reports. So you can now do that as a company, and you can submit all your filings online. So what they would have done in this situation is they would have entered into a software development agreement with a developer to create and develop that online software for them. And these are just some examples of where a software development agreement may come in handy. So I'm going to dive right in now to explain to you what perhaps the key terms are in software development agreements. But what perhaps you might want to take note of is a lot of people fail to realize, regardless of your relationship with the software developer. So I'll give you an example. We've previously, had a discussion with a client who said that their friend of a friend and someone that they know was going to create a certain software website or certain application. It was a mobile application for them. And they said, we don't need an agreement. We don't need anything in writing because we have a terms and conditions and we have a purchase order form. So we're just going to go ahead with that. That's actually not the case, because regardless of whether your relationship with someone is amicable, you need to have these agreements in place to ensure that both parties are protected equally, if not protected to the best that they can possibly be protected in terms of terms, payment terms, obligations, and warranties and representations. These obligations need to be set out quite strategically, and it's usually a structured agreement. So most software developments are very structured, and they will spell out the exact nature of the work which is required, the terms and conditions, and more importantly, specifications. So if you are hiring someone or paying someone to conduct a service for you in the form of creating a product or an online website or a software and application, you want to give them the exact specifications of what they need to comply with, how the app is going to operate, how the website is going to be run, how it's going to look, the customization of the design. And these are things that you might want to think of, that you might want to put in the agreement as well. So key terms that you probably might want to look out for in software development agreements are things like progressive milestones. There are a lot of terms which are quite legal jargon, but at the same time quite technical, I think. There are terms in digital technology industries where vendors usually use, and one of them which I'd like to highlight is something called a go live date. You'll be hearing this in the course of my presentation as well as Tommy's presentation. So just to clear things up, I'll just go ahead and explain that to you now. Go live date is usually the date on which your particular product or software is going to be launched to the public. And that is the launch date, essentially, which is going to be usually given by the client or the customer. And then the developers will have to use that date as a benchmark for when everything needs to be ready and work backwards. So it is the developer's responsibility to ensure that the go live date is met as given by the client. So in line with the go live date, you would then have something called progressive milestones. So it essentially is a tabulation that you would either find at the back of the software development agreement, or it could also be embodied throughout the agreement, somewhere in the middle. And that's essentially an aspect and terms and specifications which set out the product, the list of deliverables that need to be given. So previously I mentioned specification. So when you have a product specification, you might want to then state whether that is a particular deliverable. So one aspect of your website could potentially be the heading and the titles all need to be done by a certain date. Now that's a separate deliverable as compared to the entire website being delivered as a whole. So progressive milestones usually tie in nicely with payment terms. And that is where the client would turn around and say, okay, we have certain milestones that we need to achieve over the course of perhaps 3 to 6 months. And over the course of 3 to 6 months, we will pay you every fortnightly or every monthly in monthly progressive payments, depending on where you tick off each milestone. And that is usually a key term that is included in software development agreements so as to avoid confusion or dispute later on if a particular milestone wasn't achieved. We then also have something called testing. So it's very important for software development agreements to include testing. Now, there are various forms of testing which may be required. And this, of course, depends on the complexity of the software, the complexity of the website, complexity of the product, whether it's a mobile application which is being developed. And the reason why this is a key aspect together with progressive milestone is because that the client will want to have a method to test or to ensure that the particular product that they're paying for is tested and meets the specifications under the terms of the agreement. They would want to test whether it's working and performing in accordance to how they want it to work. And examples of testing could include different types. One is a user acceptance test, where the developer turns around and says, okay, all functionalities of the application have been completed. We've created it, we've developed it, it's now ready to be tested. You then get a dummy user. So I'll take the firm, for example. If we're using Mao & Associates, and if we have a particular digital technology product being created, we will then use it and test it amongst all our colleagues to see whether it's testing and working well. Once that acceptance test has been met, it then moves on to a final testing stage, which is the final testing stage where you would test it before it launches and go live, like what I explained earlier, which means go live to the public. So these two are key elements and key terms, which you must always try to ensure in a software development agreement, they would probably have to be there. Other terms include other things like LAD and support and maintenance. So what is LAD? A lot of the time people get confused, but LAD is actually liquidated ascertained damages. Some people refer to it as limited acquired damages, but it's actually liquidated ascertained damages. And in short, we refer to it as LAD. And for software development agreements, LAD is usually always commonly referred to for delay. So let's say, for example, if you intend to launch your product, let's take 31st of March as the go live date. If your go live date is 31st of March and the developer then turns around and tells you, okay, well, your product's not ready for launch. It's not ready, right? It's not ready because certain specifications and certain milestones haven't been achieved. You may want to ascertain the level of damages or the level of LAD that is required for that delay, because it's almost certain situations where clients come to us and say, we need this digital technology launched in 3 months. And in 3 months' time, if it's not launched, we want certain repercussions and we want certain damages paid because the developer has promised us this. So a lot of the times when you find that LAD is not included in your software development agreement means it hasn't been carefully drafted or prepared, because an important aspect of the delay in measuring how much of damages is to be paid would be found under the LAD clause in the software development agreement. And it should be drafted to entail both sides' negotiations. So you would obviously have negotiated between the customer and the developer way before you finalize the agreement so that each party knows what percentage or what measure of LAD is being used. The other aspect is support and maintenance. I will be going through this in a little bit more detail shortly, but just to highlight, not every client and not every agreement will include a support and maintenance. A very clear example of this is if I'm hiring someone to do my website and it's a very simple, it's very preliminary website which I can maintain by myself, the support and maintenance aspect isn't really a necessity, nor is it a key element. But for other aspects of it, there are two aspects. And this has to be separated into support and maintenance. There is a difference between the two. Support means supporting the main contents, specifications, and products which have been uploaded online. And maintenance is to fix things like bugs that needs upgrade, or something's wrong with it and it doesn't work. So maintenance of that needs to be done. So regardless of whether you're doing a software application or a mobile application or an online website, if something needs to be improved or repaired, you want to make sure that the developer sorts it out, especially if you're not in the information technology sector and you wouldn't know how to do it yourself. It is important to know whose responsibility it is, whether it's the clients or the developers, because most of the time developers would turn around and say, I've done my part, I've created the application for you, I've given it to you, I've handed it over, and that's the end of my scope of work. But if you have support and maintenance, and if that element is included in your agreement, that would obviously then go into many years or many months after, where you're going to do support and maintenance. Lease, and I think we'll go into a little bit more detail for support and maintenance, because that can be a separate agreement as well shortly. But the last key term that I wanted to highlight for software development agreements are this. Lease to say, actually, they're more of boilerplate clauses, which means they are clauses you would find right at the end, which are pretty much standard. And this is a representation and warranty clause, which sets out, representations each party brings to the table. It could be them representing that they're a company, they've got no litigation against them, and then you rely on that to enter into the agreement and the scope of work. We also have termination clauses. Termination clauses is pretty much standard in most agreements, regardless of whether it's a software development or not. And this obviously gives you an exit avenue for either party in the event the terms or conditions or any certain obligations have been defaulted under the agreement. And you always want to make sure that the termination clause, which is drafted out, suits the termination clause you want to include it. We've got two types of termination commonly: convenience and default. So convenience is, let's say, for example, I'm not interested in being a party to this agreement. I want to be able to have the flexibility to terminate my agreement at any point of time, regardless of whether the software has been fully developed. I would be allowed to do that. Alternatively, you have default, where parties are only allowed to terminate the agreement in the event there's a default or a breach. So these are two elements and two things to think about when drafting or crafting these types of agreements, especially when you're negotiating them. And the last part is, of course, dispute resolution, which will obviously be beneficial to both parties, so that an agreed resolution procedure can be followed in the event of any future disputes. Okay, so I think we've tied in nicely the brief elements of software development agreements. I'm just going to go now very quickly into support and maintenance contracts. So like I said earlier, support and maintenance is two separate elements, but this aspect is predominantly something which they refer to as a service level contract, which can either be incorporated into your software development agreement, or it may be a standalone contract. So this, again, depends on the type of product, the type of application, and the comprehensive and the complexity of it. If it's comprehensive enough that it warrants itself to be a separate standalone contract, then you would probably have to do a service level contract in addition to the software development agreement. If it's just a simple clause where you just need support and maintenance for a couple of months, the service fee is not very high, and there's not much work to be done, then it could probably be incorporated into your software development agreement itself. Why would you say do you need to include or address this issue? And the plain reason for this is to just simply avoid future disputes between parties as to responsibilities of who is going to maintain and who is going to support the software. So I'll give you an example of a comprehensive support and maintenance matter and transaction rather that we had. So let's say, for example, if a client engages a developer to create an online software that allows the client to input certain data to attend to queries from the public. This might be fully automated, and this may be provided on a 24 hours basis. So let's say you are in the hospital industry or you're running a medical clinic, and your business in terms of your content that you provide online is 24 hours. In the event you need an IT support help desk, or you need support and maintenance elements to come in because someone's not going to maintain it for 24 hours, this is a situation where you would need someone, or you need the developer or someone external to come in and do your support and maintenance. If your business relies solely on the software and it's for a 24-hour basis, or it's for a longer period of time that you really require an IT support help desk, it's better to outsource this And then basically what would happen is if there's a crash or the system goes offline or something happens to the systems, let's say 3 a.m. in the morning, it can be 9 a.m. in the morning, that is when your support and maintenance team needs to be on the standby, needs to be ready. So most of the time you will see that your support and maintenance would have a schedule. And I'll set this out. I think it's in the next slide. Hang on. We can go to, yeah. So the support services that you require the developer to have for you would be listed out in great detail in your support and maintenance contract, whether it's a service level of contract or whether it's included in the main software development agreement. It is worth mentioning, obviously, that support and maintenance, please remember, only kicks in after your go live date. There's no support and maintenance before the go live date, and there's no support and maintenance during which the developer is creating the software for you. Support and maintenance is only done on softwares which have already been created. And as I previously mentioned, in the event we do have a comprehensive support and maintenance element, each level and each time of maintenance needs to be included and must be spelled out very accurately. An example of this is to do a very simple tabulation at the back of your service level contract, which will then set out operation times, operation response times, and critical levels. So you could have high critical levels, low critical levels, average critical levels. And in correspondence to that, let's say, for example, if the critical level is high, you expect whoever's providing your support and maintenance service to reply to that within 1 to 2 hours so that you have a time frame. And the reason why this is important is because if, for example, you're engaging someone to do your support and maintenance, they then system crash, system goes offline, someone then comes in from the support and maintenance team and says, oh, we fixed it 5 hours later. You then realize the level was quite critical, it was quite high. If your agreement covers that, you can go back to say, well, look, the response time was supposed to be 1 to 2 hours. You have not responded accordingly in that time. The critical level was high. As such, this then ties back in, do you have LAD or not? Can you claim for damages? Can you claim for something because you were missing that couple of hours and it's caused a detriment to you? So this is typically something that would be included under support and maintenance service level contracts. And they can run for 2 to 3 months. They can run to 2 to 5 years. They can run to 10 years. It really depends how long your support and maintenance is for, whether it's short term or whether it's long term. And the pricing, of course, for support and maintenance will vary depending on whether it's a fixed price per annum. It could be pegged to a certain value depending on the response time and the amount of hourly rate they've had to attend to queries. So really, it's quite flexible in terms of what you aim to achieve and the type of support and maintenance that you are looking for. Last but not least is payment terms. So you always want to make sure that your payment terms are always included, regardless of whether it's a software development agreement or a support and maintenance service level contract. To reiterate though, please bear in mind that there are 2 types of fees that I would be referring to here. One is the support and maintenance fee. The other one is the actual cost, development cost. So that is not to be confused between each other, and they must be spelled out separately in both agreements if you are separating both agreements. Similarly, if your support and maintenance cost falls under your software development agreement, what you want to do then is your support and maintenance fee will be separate and your development fee would be separate. And it's good to differentiate the two. So that's all for me for software development and support and maintenance. I will now hand the floor over to Tommy, who will take you through other common agreements and take you through the EULA terms of use and privacy policy. Thanks, everyone. Over to you, Tommy.
Hi, everyone. Just give me a moment while I share my screen for the slides. Just very quickly. Okay, I think that everybody would be able to look at the slide that I'm sharing right now. Hi. Before I begin, my name is Tommy, and I'm an associate with Marvin & Associates for the corporate department. And today I'll be touching on end user license agreement, terms of use, and privacy policies. Now, as Cassandra mentioned earlier, the entire world is progressing towards digitalization of their businesses, or even entrepreneurs are coming up with ways to allow everybody in the world who has access to the internet or the World Wide Web to be able to have the privilege of using these online websites or even service platforms or even apps. So thank you, Cassandra, for providing an insight onto software development agreements and also support and maintenance contracts. Now, these things tie in very, very although indirectly, but they are very, very important to the fact that what terms are being governed under the end user license agreement, or even the terms of use for the matter. To begin with, I will touch on the end user license agreement. In short, the end user license agreement is an agreement between, for the purpose of this talk, it is a agreement between the software publisher, being the owner or the author or the publisher of the software application or software, and the software user, being the user or the purchaser of the software or the software application. Now, under these end user license agreements, it is basically setting out the terms and conditions under which the software publisher allows or provides the software or the software application for the software user to use the software or the software application, which is why there's this term called the license in the agreement, end user license agreement. Ultimately, it is a license for the software user I wouldn't say operate, but to use or to download or to install the software or the software application. Why? The reason why the term license is being used is because now, as a software publisher, you will have the task and the duty to undertake or undergo from start the software development agreement and also the software maintenance contract. Although sometimes the agreement and the contract may be merged together. Now, as the owner or the publisher of the software, you are technically intending to be the sole owner of such software, which in turn will allow you to be the owner of the intellectual property. When you provide or grant the license to the end user, you are essentially providing a license for the end user to use your intellectual property. Or even though it is commonly known as end user license agreement, sometimes it may be referred to as a software license agreement. And typically, such an agreement, or for the purpose of this talk, we'll use it as end user license agreement. The end user license agreement will typically be provided digitally. This is due to the fact that the world is being digitalized continuously. Now, dialing back years before where we are currently, for example, if you are intending to purchase or to use a software such as antivirus programs and this and that. Now, previously, when the world is more physical and technology is not so digitalized, you'll be required to go to a store to purchase these programs from this distributors. Now, when you purchase these programs, it usually comes in a box and there's a disc or a CD attached to it inside. Now, before you use the CD or the disc to download or install the program, there will be a little leaflet or booklet which sets out the terms and conditions under which you'll be obliged to accept and to acknowledge before downloading and installing. Now, as the world is currently in 2021, and in light of the COVID-19 pandemic, a lot of businesses, a lot of programs are being digitalized, and it is the pathway for you to download and install and to use these softwares and applications available on their respective websites. Now, when you click on the link to download and install, prior to downloading and installing, there will be a pop-up screen whereby the terms and conditions under the heading, the end user license agreement or the software license agreement for the matter, you have to obviously peruse it, understand it, acknowledge and accept it before you download and install. So that is essentially the end user license agreement. Oops, just give me a second. Okay, now, as I mentioned previously, it is, as of now, in this current state and in the current world of digital technology, you'll be able to download these apps, these softwares, or whatever programs digitally online without purchasing any hard copies of these programs. Now, there's this source where, for example, on the screen, there's a Turn-in user agreement. Now, before you use it, before you download or install it onto your devices, whether be it mobile or a computer, you will have to peruse and understand these terms and conditions under which the end user license agreement sets out. Now, ultimately, I will will distinguish the difference between the end user license agreement and the terms of use. As a matter of fact, if you can look closely, they will set up basically they will allow you to have an idea and the understanding into which the terms and conditions apply to your download, installation and use of the program. Now, there are many, as with all other agreements, there are, due to the different industries and sectors that digital technology is in, there are many other key terms in an end user license agreement. First and foremost, the main and key term is the fact that the software publisher will grant the right or the license to the end user or the software user for the matter to download, to install, and to use the software or the application. Now, the software or the software application in question is the intellectual property that the software publisher is providing a license to you. Below that, there will always be the limitations of use, whereby the software publisher will always intend to limit how you use the program, whether you can copy it, whether you can duplicate it, and or to even distribute it for the matter. So this governs, or this sets up what you can't do in terms of you downloading, installing, and using the app. Now, if in your mind you probably be thinking, oh, this is probably similar to the terms of use, but there's a fine line of distinction between these two, which I'll touch on later. Now, as I mentioned earlier, the licensing that software or the software application is essentially licensing the intellectual property that the software publisher owns, or whereby the intellectual property rights are vested in. So this actually goes hand in hand. If you think about it, it goes hand in hand with any other licensing agreements or clauses. Now, whatever that you have in terms of it being an intellectual property, it is yours. It is your ownership. It's under your ownership, and it is your product. Now, when you license something to someone, obviously the agreement will set out the ownership, the owner, and whether or not these intellectual properties are exclusive or non-exclusive. So this is very important in terms of an end user license agreement for the purposes of this talk. In terms of limitation of liability and damages, now, because these softwares and the applications are digitalized, they're in terms of being under the purview of the World Wide Web and internet, there cannot be a guarantee, and very usually, or rather most of the time, software publishers will not guarantee or provide a warranty of whatsoever that whatever software or software applications that they are granting you the license to will be free of errors or free of malfunctions or even downtime. Now, the limitation of liability or damages clause will essentially set out that they will not be responsible for any damages that is incurred by the software user in the event that the software application or even the software does not meet the software user's requirements or expectations for the matter. Now, in addition to this, as important as it is for the software publisher to set up the terms and conditions whereby they are granting you the right or license to use the software or software application, they will also set up termination, the termination of the end user license agreement. Now, as Cassandra mentioned earlier, termination it is basically an exit strategy for parties in an agreement. It is very important because now, whereby there's a breach or there's a dispute or whatsoever reason, such as convenience, there's an exit strategies for parties involved in an agreement to exit the agreement. Now, obviously, being a party in an agreement, there will always be an avenue for you and the other party to resolve such claims, disputes, or differences. But obviously, if you are bound to an agreement, you are obliged to carry out your obligations. So termination clauses are basically an exit strategy for the parties to exit. Now, I believe, as I mentioned earlier, I will be speaking on terms of use, whereby I would think that some of you would be confused as to whether the end user license agreements or the terms of use will be similar. I'll touch base on that at the end of this topic. Now, as earlier I've mentioned, the end user license agreement governs the terms and conditions under which the software publisher and the software user will be using, or rather the software user will be using the application to download, to install, to use. Now, the difference now where it is distinguishable between a website, an app, or a software for the matter. Now, under the website or a software application, the app itself is one thing. In the app or in the software, or for the matter, there are services in which the software publishers allow or to provide to the end users. Now, these services are governed under terms of use, not particularly. It's yours. It is your ownership. It's under your ownership, and it is your product. Now, when you license something to someone, obviously the agreement will set out the ownership, the owner. The terms of use are also commonly known as the terms of service. So just to simplify it, end user license agreement is for the app. Terms of use is for the service within the app, for the matter, just to simplify it. So the terms of use will be set out in the website, or a little link that is obvious and displayed within the app before or even during your use of the app itself. For example, WhatsApp is downloadable by or installed by Apple App Store or the Google Play software. Now, perhaps they have their end user license agreements there. When you have downloaded it, you have installed it, and prior to your use to that, for example, you have your user accounts and this and that. How you register or how to use the app itself to register an account, it is all governed mostly under the terms of use. So the terms of use essentially is an agreement that the app user or the service user will be required to agree and to understand and to acknowledge for the purposes of using that service itself. Now, for the context of websites, the websites don't have end user license agreements. Usually, if you scroll down in a website, for example, our firm's website, you go down, there'll be terms of use, there'll be privacy policies. There won't be an end user license agreement. So how you use that website itself, because it's a service, it governs how you are to simplify your behavior and your conduct with the service within the website. That is a simplification of understanding. Now, let's say you are using GrabCar, GrabFood, Instagram, or WhatsApp. If you go to your user profile, to go to your settings, you will be able to find terms of use or terms of service, or even sometimes commonly known as terms and conditions. So this governs your use of the service within the software. Now, the key terms in terms of use, although similar to an end user license agreement, there are certain distinction between the two. Now, first and foremost, terms of use will essentially set out the type of service or services that the app or the app owner is providing you within the app or the software. Now, for example, in the slides about our services, they will set up what they're providing. Is it a messenger platform, e-commerce platform, or whatsoever that the service that they're providing? Now, within that, there will also be clauses such as how can you use the platform? How can you use the service? Are you required to register for a user account? What if the app has an option for the end users to use, such as a user account or a merchant account? So they set out these requirements under which, how are you supposed to register for user account, or how are you supposed to register for a merchant account? There will be different distinctions between the two, for example. So now, when you have, I believe everybody has an account with an app or software such as Instagram or Facebook and this and that. Now, when you register for an account, whether it be a user account or a business account, you are required to enter particular details about yourself or your business, for the matter. Now, these are personal data and information, and which I will touch on later on in the slides. But under terms of use, it is very, very important for these service providers to inform and to allow the user to know that they have a privacy policy installed, because personal data and information is very, very important to each and every individual being, because data and information, it is essential to a person or even a corporate entity, because you would not want your information or personal information or data to be disclosed to every other individual who's using the app or any other third-party providers as well. Now, under the terms of use, they will essentially set out that they have available these privacy policies, and they will typically not set out the whole policy in the terms of use, but they will hyperlink the domain to their privacy policies, which I'll touch on later. Now, licenses. This is essentially being a tie-in between the end user license agreement and the terms of use. Now, typically, mobile apps, they will provide for an end user license agreement either within the terms of use, or the terms of use being lumped into with the end user license agreement. Now, although license is an important part of any mobile app or software applications for the matter, there will either be an end user license agreement or terms of use whereby the grant of license will be set out or even duplicated for the matter, because it is that important. Now, in terms of limitation of liability, now every individual or corporate entity who intends to license the intellectual property will limit their liability, as I mentioned earlier. Now, when it comes to service within the software, now when you've downloaded, you have installed, and you are using the app, that you will essentially be using the service within the app. Now, what if, for example, you have downloaded GrabFood, but the Grab app, you got Grab Car, you got GrabFood. Now, they will, as I've said earlier, digitalization will not guarantee you a smooth sailing path of use. Now, there may be a downtime, for example, such as if, let's say, you have ordered food on GrabFood, and let's say that day itself you ordered, and there's a vast order of food and this and that, and they cannot provide you within the time frame that they have sort of indicated to you. They did not guarantee, and because of this unforeseen event, this is where the limitation of liability for them comes into play. So they will always, software publishers or app providers or service providers will always limit their liability or responsibilities for the matter in terms of these unforeseen circumstances. Now, when you are using the app, I've kept on going about how you are restricted from using the service from this and that, this and that, this and that. But they will also set out what is acceptable in terms of using the software or the service or the app itself. This typically provides such as acceptable use in terms of providing information that is beneficial to all users, this and that. Basically, those that they allow you to use the service for the purposes and intents that is intended for the service between the users itself. Indemnification, it is also as important as any other clauses, such as termination in any other agreements, whereby in terms of use or even end user license agreements, where the software publisher or the service provider will be indemnified, defended, or held harmless by the user against all liabilities, damages, losses, and expenses of any kind arising or in connection with the user's use of the service or the app, or even in relation to the breach of the terms of service or terms of use on the part of the user. So this protects the service provider or the app publisher or software publisher themselves. Okay, I believe that I'm touching on the last part of my slides in terms of privacy policy. Now, just a few moments ago, I've mentioned that the terms of use would essentially or usually cover the privacy policy, although not fully or completely, but they will set out like the user will have to agree to the privacy policy, which is accessible under the link below, and you click on the link, or even for the matter, when you're using the app, there will be a click wrap that allows you to access the privacy policy, whereby the policy will set out the terms and conditions under which such an app or service provider informs the user on how their respective data and information is being collected, handled, processed, used, disclosed, or even stored. So data and information, again, they are very, very important to each and every individual and entity themselves. Now, when you are, let's say you're being a merchant on a service platform, obviously the the corporate entity cannot be the one registering for an account, this and that. Now, obviously, the entity will have a representative. Now, when you are registered for an account, the representative will be required to provide their own information, their own personal data, date of birth, position, who you're representing. So these are still information and data that is very important to the entity that they are representing. Now, because the world of technology is progressing each and every day, when you are using a service platform online and digitally, when you are intending to use such platforms, you will be required to key in or enter your data, your information, such as your date of birth, your residential address, how they can contact you, your email address, and even sometimes by way of cookies, website cookies or domain cookies, you will have your IP address, these little digital, these digital informations that you may or may not be aware of that you're providing them with. So ultimately, when you're using an app or a website, there will always be a pop-up notification that we are using, do you allow for the cookies to collect or to store your data, this and that. Now, usually we just click OK, accept. Now, but obviously to understand cookies is very important because these are small little tiny bits of data that you may or may not be aware of. So it is always important that before anything else, if let's say you are sensitive to your personal information data, it is essential for you to look at the privacy policy, because how they store it is set out under, I put it on a slide such as personal data and personal information. Now, this is just a general heading that is for convenience for this talk, but under a privacy policy, it is separated into a lot of clauses, such as, for example, if I am a service provider, how we collect information, how we use information, why, when, and how we disclose information, to whom we disclose information, how long is the data or information being stored. Now, sometimes when you're using their service, they're generating revenue from you because you are their customer. For the purposes of their corporate obligations, for audit purposes, legal purposes, or tax purposes, to ascertain and to tally up their documentations, they will probably be disclosing each transaction with the personal details and the personal information of each and every customer that they're engaged. So for example, disclosure will be set up under methods and how disclosure is being made to third-party service providers or even third parties in itself. So now data and information is very, very important. It is essential for users to understand, because each and every privacy policy between service platform 1, service platform 2, it may or may not be completely different in terms of storage, use, collection, or processing of the data. Now, perhaps privacy policies applies to third parties as well. Now, such information includes those from third-party platforms or individuals that provide the service provider, for example, the support and maintenance. Like Cassandra mentioned earlier, if let's say I am platform XYZ, I've engaged company ABC for service and support and maintenance, some privacy policies will entail, or even in terms of use, will provide or set out the information of such third parties as well. Now, as I've said just a few moments ago, disclosure. Obviously, now when we register or when we use the service platform, we will entrust our data and information to them, that they will take reasonable care of such data and information that we have provided them with. So when you enter the privacy policy, you will see the avenues and the circumstances under which disclosure of such information or use of such information that we have provided them with. And if you're not agreeable to it, the user or the customer will have the right to discontinue use and to request that or to object for such use or information that that the user has provided them with. Now, the personal data and information in Malaysia is governed under the Personal Data and the PDPA 2010. Now, for the purpose of that, the people collecting information is usually termed as the data user, and the people who provide personal data and information is known as data subjects. Now, under the Act, the data subjects, under certain circumstances, will have these following rights and obligations. For example, let's say I am the data subject. I provided my information on platform this and that, on platform A. Now, because they will usually set out that the data user will usually provide that I'm under the obligation and I'm responsible for providing true and accurate and correct information about myself or the entity that I'm representing. Now, in the event where I come to realization that I provided any incomplete, inaccurate, or untrue personal details or personal data information, I can contact them by the contact details at the very, very bottom of the privacy policy to request for correction or amendment of the details that are provided to avoid any disputes or any unnecessary claims or differences between myself and the data user. Another one is, again, objection. Now, perhaps sometimes before we use the service, we register ourselves, this and that. Once we have access to the service platform, we peruse the privacy policies of that service platform, and we look at how they allow themselves to use, to disclose, to process, to collect data, and we are not particularly agreeable with it, and we are not comfortable with how they do it. We can request that our details, this, name of birth, date of birth, name, residential address, this and that, to be objected from being disclosed or even being used. So you stop it there, right there and then. And even so, under circumstances, you may even withdraw your implied consent or express consent for them to use such information that you have disclosed. Now, the purposes of a privacy policy is very, very simple, being that the availability and the knowledge and the disclosure of the privacy policy itself is required under law. Most of the times, if not every time, required by third-party services. And having such privacy policy in place for your users to know will ensure and promote transparency between you as a service provider or even you as a data user, between these two parties. Now, this ties in with disclosure very, very much, because sometimes when I'm on certain times, if let's say my company is a service platform, I may or may not foresee that my company may be acquired by another entity. If let's say I foresee to be such a way, or even if I don't foresee, but I just want to include it there as a service provider, any data being collected from my customers and from my company's customers, I will let them know that if in the event there will be a change of control within my company being acquired or being merged, this information will be transferred to them. Although this is not in all privacy policies, but there are some that allows for this. So the users will have to be very, very mindful of such clauses. Now, as important as I've amplified it to be, now when we are using service platforms for ourselves, we tend to, just because we want to use it, we just tend to just provide our personal information without having a knowledge of how it is being collected, being used, or being disclosed. Because personal data and information is very, very fundamental in terms of pinpointing or identifying that information provided to be an individual. We tend to forget it because we are using a service platform and we believe that it's just being done and dusted. Therefore, it is as good as whether you are comfortable with you providing your own personal data and details to another human being who's right in front of you requesting for it. So even though the world is being digitalized, every user will have to be mindful of how and to what extent their personal data and information is being collected, processed, handled, managed, stored, or even used or disclosed. Now, the digital world is, again, as Cassandra mentioned earlier, is being continuously progressing, and there are many technologies being invented whereby data and information will be required. Sometimes for compliance purposes, additional information will be required. So to understand your rights and obligations, under which, for the matter, even end user license agreements, software development agreements, these agreements will protect you from many future and unnecessary disputes, differences, claims, and even arguments for the matter. Because the digitalization of the business world is continuously progressing, and we are technically in the early stages because of how we have conducted businesses in the past, whereby it's all physical, this and that. Every user of technology will have to be mindful of how they provide and how they progress with their data and information. Now, even aside from privacy policies, terms of use, this and that, it is as good as the terms and conditions under which you are obliged to satisfy in any other contracts as well, because it is still a contract between a user and provider in terms of that platform or the app or the software itself. Now, to wrap it up, before we take questions, as a developer, obviously you have to be able to protect yourselves, and as an end user, you always have to be mindful of how you are restricted or allowed to use the software application, and even how you are providing your data information, how your information is being processed and handled and being used for the matter. So with that, I will conclude my time with the slides. I hope I did not take too much time. Aaron, back to you. Thank you. Aaron?
Thank you, Tommy, and thank you, Cassandra, for your wonderful insight. We will now move on to the Q&A session and to take questions from the participants from Slido. For all the participants, you can feel free to ask our speaker anything regarding to any of the legal agreements in digital technology. And once again, you can scan this QR code to access this Slido page, or go to the Slido website and key in the number 23481. So for our first question, on registered digital exchange license, companies who operate cryptocurrency exchanges, must they go through these agreements mentioned, or it depends? Cassandra, would you like to answer this question?
Yeah. Sorry, so just to reiterate, we're taking the digital exchange question, right? Right, Aaron? So it's the registered digital exchange license question.
Yes, that is correct.
So I think, I'm not sure what the question thoroughly entails, but if you're referring to agreements where you would have to enter into a software development agreement, then yes. Because how cryptocurrency exchanges work is they work on an online platform. If an in-house company that would obviously develop your own cryptocurrency exchange platform, which is a DEX exchange platform, then no, you wouldn't have to enter into this agreement if you're doing it in-house. But if you are hiring someone else, which are third-party software developers, and they are usually referred to as white label exchange software developers, if you're asking them to generate or create or develop that cryptocurrency platform for you, then yes, it is very helpful and quite likely that you probably will be entering into a software development agreement with them. Yeah, that's all for me. Thank you.
And for the next question, so a software developer provides support and maintenance with warranty of 60 days. The go-live date is the 1st of April. Is effective date of support and maintenance 1st of April or 1st of June? I think this question goes to Cassandra as well.
Yes, so for software development, if you're referring to support and maintenance, usually when you say a warranty of 60 days means that it's not really support and maintenance, it's a warranty period that software developers give after 60 days after the go-live date, where they kind of warrant that the support systems will be working and maintained, and that is for 60 days. So the question here is, if you're referring to whether or not your effective date should be 1st April or 1st of June, I think this depends on what your question is. If you are entering into a separate support and maintenance agreement for them to maintain the development or support of software after the go-live date, which is after the 60 days, then your effective date for the support and maintenance service level contract will fall on the 1st of April. Depending, we've done two types of agreements. One agreement is that the support and maintenance starts on the go-live date. Another agreement is they've given a warranty of 60 days, which is catered for under the software development agreement, which then means that your support and maintenance service level, which is separate, will then start on the 1st of June. So I suppose to answer this question, it would depend whether your support and maintenance clause is embedded into your software development agreement or it's a separate service level agreement. And that would be the difference on whether your effective date would be the 1st of April or 1st of June. But this effective date, bear in mind, should be your support and maintenance effective date. The effective date of the agreement itself for software development should be the start of when the development starts. So I hope that answers your question.
Thank you, Cassandra. Now for the next question, is there a website or software that helps skim through onerous terms of service and privacy policies and highlight the red flag for users like us? Tommy, would you like to answer this question?
Yeah, skimming through terms of service and privacy policies and highlighting red flags, well, it goes under the standard understanding that if you are using or wanting to use an app and there's an agreement, the user himself or herself will have to go through it and once you click accept and acknowledge, and thereby you are already accepting it. Whether be it there's a website or software that helps skim through terms of services or privacy policies, I'm not aware of, but as a user, you will have to be responsible for the terms and conditions that you agree to prior to using the software. So if you don't agree or to the use to any of the terms of service or privacy policies, then you shouldn't be using it altogether.
Thank you, Tommy. Now the next question, for software as a services companies, should it be governed under terms of service use or end user license agreement? Tommy, would you like to answer this as well?
Yes. Well, ultimately, software as a service, it can be both. Being when you license that software to another party, there will be an end user license agreement governing that license of the software itself. Now, terms of service will then govern how the service within the software is being used, as I mentioned earlier. So every software or whether it be it an app or whatever, it can always be included with both the terms of service or even the end user license agreement.
Thank you, Tommy. Now, the next question regarding to if a company sells third-party software, can we just include the third party's terms of service and privacy policy in our contract, and how to protect ourselves? Tommy, over to you.
If a company resells third-party software, can we include? Ultimately, then, in terms of that, obviously, it will completely, or rather, be quite heavily dependent on what the terms of your agreement with that third party is, because each and every agreement is different. Now, how to protect yourselves is if, let's say, you have several obligations as a party to the agreement with the third party, it may or may not be a back-to-back agreement. So it all depends on how the terms and conditions are being drafted and under which you're obliged to adhere to.
Thank you, Tommy. And the latest question we have is about the SDA also needs to add IPR clauses in detail. And Cassandra, would you like to answer this?
Yes, so the software development agreement will definitely entail intellectual property clauses. And the reason for this is because when you develop a software, at the end of the day, you're pulling information from the client, and then you're also pulling information from the developer. So the new IPR right, you will have to ascertain, does it belong to the developer or does it belong to the customer? And this will usually be parked under something called source codes. You also have source codes under the software development agreement, which is your main embodiment of where all your codes are for that software. So if the source codes ultimately goes to the client at the end of the day, then rightly so, intellectual property should vest with the client at the end of the day. So it really depends what both parties want. We have done agreements for software development agreements where developers actually retain the source code's rights and the developers retain all intellectual property rights. But this proves a problem later down the line because when the client wants to sell their particular app or sell the software or sell that particular digital information, they can't. So this is something to bear in mind and be very careful of.
Thank you, Cassandra. Any further questions from the audience? If there's no any further questions from the audience, we will conclude today's session. Thank you, Cassandra and Tommy, for your wonderful insight. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming corporate talk entitled E-Signatures and Digital Signatures in Malaysia in collaboration with Dropbox. And the speaker for the talk will also be Cassandra, who is also the speaker for today. And the date of the talk will be 8th of April 2021, which is on a Thursday. You may sign up at our website, which is shown in the slide or go to the event tab of our website. Secondly, please fill in our feedback form and tell us what you think of our talk. The link to the form will also be posted in the chat box on the bottom. Thirdly, follow or like our social media account. The links will also be posted in the chat box as well. And fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted on the chat box as well. And to our guests, thank you for joining us. We hope that you have found today's session informative and useful in the current climate.